Wait, please, Your Lordship.
Yes.
Item number 16 of today's list, my lord, is in the hearing column.
Hmm.
It's taken away the brief. And I have informed the client, so I'm not appearing in the case.
No issue.
Happy lawsuits.
Hmm.
I beg to mention for listing 1 2019 matter, 6-month conviction matter.
Huh?
At 6-month conviction matter.
Bail is you are on bail?
Yeah, yes, Miller.
Wait for something.
Miller, due to pendency of the case, Miller, petitioner not getting appointment, Miller. He has selected already Mondal as a Mondal, Miller. Due to pendency of this case, he is not selected. He appointed, Miller. That's why, Miller. 6-month conviction, Miller. Gambling.
First week of January. Give a date.
First week.
First week of January. Not possible in December.
Okay, sir.
No? Or you can make a repeat your prayer. Maybe second or third you make a mention on December. By that time we'll know how we are proceeding.
Okay.
Yes.
Lordship, item number 2, Lordship. I am for the informal Lordship. I have filed an affidavit in opposition Lordship on yesterday. That may be called for Lordship.
You are for?
I am for the informal Lordship. Respondent number 2.
And what is item number 3?
Carrying out the same FIR Lordship.
What requirement? You are for the respondent. You have filed affidavit. What will you decide in an affidavit in a criminal petition?
I
Are you proposing to go for a trial? Okay, when have you filed it?
yesterday Lordship.
Okay, give a date next week. Yes, Mr. Mohanta, you are also there. 19 matters, so you are not so keen.
I am not so keen, but we have a case, my lord.
No, you might have a case.
Yeah,
So therefore, let it come.
my lord.
He has filed an affidavit.
In my case, they have not filed, but same FIR, but
Same
in
FIR.
two, my lord.
They are the informant.
He is the informant. In two, my lord, one of the petitioner, one of the accused, my lord, he is representing.
Okay.
uh,
So one
and-
FIR is challenged by both of you.
Yes,
He want to file an affidavit in one that will cover. Give a copy to both of them.
my lord.
And I do not know what affidavit we can
Yes,
in a
sir.
quashing petition. Okay, you have filed it 2019 matter. Next week, give a date. What is the FIR about?
There is actually, my lord, regarding mutation. That mutation, some, my lord, discrepancy is there. They file a complaint case first. Thereafter, my lord, complaint case means, my lord, going on, but they are not succeeding in the complaint case. They file a FIR. But in FIR, they have not mentioned that they have filed a complaint case.
Oh, that case. We have fixed matter. That's why.
That's the case, my lord.
Okay. Next week, give a date.
My lord.
3rd of December.
My lord, support. Deeply.
It is submitted by the learned counsel for the respondent that an affidavit has been filed. Full stop. Same is not on record. List this matter on 2nd. In the meantime, registry shall verify. 3rd of December. In the meantime, registry shall verify and do the needful for bringing the same on record if already filed.
Deeply.
Yes.
Pray to mention for listing of criminal petition, 800, petition number 811 of 2019.
Wait. You make a mention on 2nd, 3rd or 4th December. Okay.
Please.
Let us at least handle till 2017.
Right.
Then we'll come back to 19. Yes.
I please your lordship.
Lordship, item number 12, criminal revision petition number 89/2012. Lordship, my senior is a little bit ill today.
Take care of him. You will
Take
take
care
care of this case. Okay.
Item number?
No, we are not entering.
No.
Take care of him. We will take care of the case. Yes.
I have to make this criminal revision petition number 258/2014 for hearing. Listing for hearing.
Which year?
On-
No, which case of which year?
2014.
It will come. It will come. What is the give the number? Case number?
Criminal revision.
Give it
petition.
to her. Give it to
I
her.
will.
It will come. It will come. No worry about this.
Lordship, with regard to item number 1,
Yes.
item number 1, last order reflect that Mr. Kyle appeared. And he apprised this for honorable court that the matter belongs to Rose Valley group of people. So, and my name has been reflected. That what instruction I have to sort, Lordship, it is not.
No, only thing you will have to seek is that this is challenging an FIR so far relating to Rose Valley. Now, the commencement of FIR is by an officer of Rose Valley. Okay. At that stage, Mr. Kyle says that in fact, all these offences are being investigated by the CBI. So anything remains in this case, and whether CBI search it, he is an accused. That much. Give a copy to.
But here's the difficulties, my lord. The person who filed the petition has already expired.
To
So
matter
nothing-
as
nothing
there.
remains.
Why
Nothing
should we? That you ought to have said on the last occasion. Unnecessary, we have called Kyle. Unnecessary, we have called him. Huh?
He was not there in the last occasion.
No, he was not there. That's why we have to pass this order.
Sorry.
This is the difficulty. Mr. Bhattacharjee, learned counsel for the petitioner, submits that the petitioner has in the meantime expired. Therefore, no cause of action survives to pursue this criminal petition.
Absolutely.
Full stop. In view of the aforesaid, criminal petition stands closed, being infructuous. Interim order, if any, stands vacated.
May please, your Lordship. Lordship will fix this matter for hearing today, my lord, but it has again come for order.
Orders, okay.
I am otherwise ready, my lord.
What is the issue here?
The appellant was convicted, charged under 307, 326 and 324. Time of judgment, my lord, 324. Basically, 3 injuries were found, my lord. One injury was found on the head, at the left side, one injury was found on the neck, and my lord, one injury was found on the back side of the head. And doctor had said that these injuries could not have been dealt by one blow. It was proposed by the defense that he had sustained the injury by falling down, but doctor ruled it out, saying that this could not have happened by a single blow. And some exaggerations are there, my lord, in the testimony of the victim, but by and large, the
So
fact-
that exaggeration is not material.
because of the fact that this injury, the medical was conducted on the day of the incident, 22/12/2005. Incident takes place on that very day. This person was medically examined and doctor finds this injury. Victim deposes categorically that the appellant had hit him. There is also some issue regarding theft of some bags of cement, apparently stolen by the appellant, my lord, but that was not true. And there was one eyewitness, one Pratyush Nath, my lord. He had snatched he was hit by an axe, my lord. He had apparently snatched the axe. Pratyush Nath turns hostile, my lord. So this part was not corroborated, but he was, when he was cross-examined, his evidence could not be broken. But at least the view that he propounded, he tried to depose in line of the defense that this person fell down. So he was cross-examined on that part and denial was there. Now the other witnesses have said that Pratyush Nath came and informed the brother and another person that Pratyush Nath came and informed us that the appellant had hit the victim and this victim was being brought. Subsequently, the brother and others, my lord, took him first to the police station, then to the hospital. Primarily is whether your lordship will go by the sole testimony of the injured. considering the
If sole
fact that-
testimony is corroborated by medical
Medical is
evidence.
corroborating, my lord. I have otherwise gonna prepare a small paper book because everything is in Bengali and handwritten, my lord.
How many matters fixed today for here, tomorrow for hearing? We'll take up this tomorrow.
Tomorrow.
Okay. Because since it was in order, I have also not gone through the things. List this matter for hearing tomorrow.
Then, sir, my lord, there's some problem while recording the cross-examination suggestions and all.
I will see that tomorrow.
Week, lord.
I'm keeping this paper book.
My lord.
Are you having a copy?
Yes, my lord, I have a copy. Week, lord.
But you have type also something. Please keep ready a soft copy.
Of course, my lord, yes, my lord.
That whatever you have typed. Okay. That will
One
help.
part is in Bengali, I've translated and typed, others are handwritten, I've typed.
Yes.
And for the respondent lordship.
Yes.
We have filed our affidavit, pleadings are complete.
Where is the crossing of?
Complaint.
Okay, where is the complaint?
Complaint petition is at page
Hmm.
32, annexure 6. And you will see that the complaint petition
Hmm.
is as vague as anything. They fail to mention, my lord, they fail to mention
Just a minute.
under NIF.
Why are you saying this is vague? Please tell us.
My lord. He said that we purchased two checks, two machines.
Hmm.
The amount of the machine has not been mentioned in the complaint petition. It has not been mentioned in the legal
Amount of amount of
amount of the two machines.
price of the two machine.
Yes, ma'am.
Two machine not mentioned.
My lord, how much
And then
and how much we have paid,
Hmm.
how much amount remains, that categorically has not been stated,
is it necessary?
my lord. Because my lord, it's a case under section 138, my lord,
Therefore.
that recoverable debt,
Hmm.
it has to be stated.
Hmm.
And regarding recoverable debt, my
Hmm.
lord, that is not under presumption, my lord. That is the law laid down by the Supreme Court. Now, my lord, kindly come to the facts of the case. Before proceeding further with the I will come back to the complaint petition again, my lord.
Yes. Yes.
My lord, purchasing two stone crusher machines
Hmm.
from the complainant.
Hmm.
We are using that,
Hmm.
and while using that, my lord, there the product that comes from the machines,
Hmm.
not as per the specification. My lord, it's produced only 20% of the promised quantity. Then, my lord, what happened? We filed a title suit.
Just a minute. Just a minute. Okay. Yes.
For the all the machinery, we are not getting the 100% of the products which promised by the complainant.
Hmm.
Then what, my lord, we have filed a damage suit before the Bangladesh court.
Hmm.
There they appear and they file one petition for transferring the matter to the High Court, to the Court of Kamrup. Then, then that was rejected. Against that, they approached the Honorable High Court. And ultimately, it was remanded back and passed the order in their favor. Then we have challenged that order, and that is pending before this court, madam. But kindly consider what is the prayer of our suit. Kindly come to the plain, pilot. That is at page 42, annexure 8.
Yes.
And kindly come to the prayer portion, my lord. We took loan and we paid the amount, entire amount. Let them say that we have not paid. my lord.
No, Mr. We'll understand everything. Let us see the prayer first.
A decree declaring that the machines TEDx power screen make track mounted primary crushing plant, TEDx power screen track mounted primary crushing plant and double deck screen model PEX 1000 SR being purchased by the plaintiff on 25/1/2015 from the defendants by investing.
So
huge amount-
fundamentally, your case is that the machine supplies were defective, and therefore you have already filed a suit for recovery of money.
Money.
So according to you, there is no liability.
and enforceable.
No, there is
debt.
no enforceable.
liability.
There is no enforceable debt.
Liability.
Now, can that be decided here?
My lord,
Will you not be able to lead all this defense that this is my case, this is not enforceable due?
my lord.
How can we now we'll have to decide, say in your favor, quashing that this debt is not due. Then we are not only deciding the suit, but also deciding the whole complaint. Is it permissible under exercise of 482? Please tell us.
I have basically 2 points. Number 1 point is as because this suit, my lord, which was filed before the complaint, my lord, before issuance of the process in the complaint case, my lord, this shows that there is no enforceable legally debt.
No, it is your case.
My-
There is no
my-
enforceable deal.
My lord.
Had there been a decree in this suit, we could have understand. Now you are asking this court to decide that there is no enforceable debt, liability. That can be done only by leading evidence.
Kindly consider one thing. This matters has been placed before the trial court, and the trial court passed the order. Kindly come to that order, my lord.
If you can show that there is a order that no proceeding is stayed, something like that, where is that order?
Is 62, annexure 10.
Exactly correct order.
Hello. The trial court below said that I don't have inherent power. Inherent power to dismiss the complaint. So that's why the petitioner is before your
So
lordship.
please tell us, enlighten us, an inherent power, we can adjudicate matters into facts and declare that there is no liability. This can be based your defense. Tell us, sir, tell us.
I'll come to that, my lord. From the judgment, I will show it.
Yes, first.
Yes, before that, my lord, that is one point.
Hmm.
The other point is, my lord, whether prima facie a case has been made under section 138.
Yes.
My lord, I'll rely on section 138.
Yes. In NI Act. Yes.
Prisoner of check
Hmm.
for insufficiency, etc. of funds in the account,
Hmm.
where any check drawn
Hmm.
by a person on an account maintained by him
Hmm.
with a banker for payment of any amount of money to another person from out of that amount
Hmm.
for the discharge in whole or in part
Hmm.
of any debt or other liability is returned by the bank. My lord, it has not been stated
Hmm.
in the complaint petition, in the legal notice, or in the initial statement
Hmm.
that this much is the debt.
Hmm.
No whisper. My lord, the law is that, my lord,
Hmm.
as held by the apex court, my lord.
Hmm.
You have to specifically mention the amount.
Okay, that can be a ground. Let us see. So you are
Only-
going to a case where you are asking us to do your defense case, failed your defense case. That we cannot. Now you come to these technicalities that your first ground is that the amount is not maintained and it is necessary. You argue that.
Yes, my lord. On that, my lord.
Now let us come to the complaint first.
Yes, my lord.
Page.
So complaint petition is
Hmm.
at page 32.
Hmm. Now kindly come to paragraph 5 and read it. Page 34. Read it.
That in discharge of legally enforceable debts towards the complaint,
Hmm.
the accused number 2,
Hmm.
in the capacity of partner of accused number 1,
Hmm.
issued 12 numbers of checks in favor of the complainant, bearing check number,
So.
out of which 9 checks amounting to rupees of 10 lakhs each.
Hmm.
Check bearing number so and check bearing number so were an amount of rupees 11 lakhs and 5 lakhs respectively.
Hmm.
Total be 1 crore 6 lakhs.
Hmm.
And the
Should have said it that for discharge of liability, these are the checks which amount has been given.
that will not do. my
That
lord.
will not do.
That will not
Okay,
do.
please first.
Only thing is, my lord, today I have not brought that judgment, my lord.
Oh, that cannot be. That cannot be.
Can
We are arguing a matter of 2017, and in the midst you will say that I am not ready.
Lordship, I will be having some difficulty. Very sorry to say. The two already some matters are fixed. There my brother.
You handle whatever. We are not. Sir, this is not expected from a lawyer like of yours, sir. That you will in the midst you will say. And what is your other points? So, okay, you understand that there is no specific amount. That total debt is so and so. Therefore, this is bad. No prima facie case is made out. Second.
Second, my lord,
Hmm.
the accounts has not been given. The value of the machine and the amount I have paid. And the remaining amount, that has not been.
So according to you, there must be a specific statement. What was the debt, actual debt, total debt, how much has already been paid, and what is remaining, and until and unless that statement is made, a complaint is liable to be quashed. These two grounds. And third is that I heard this is my defense, this is actually not due, therefore, this is at third ground. And anything?
And the checks way, we have paid the entire amount. Checks way for the securities pilot.
Yes.
At the beginning, when the machinery was not installed,
Okay.
these are the grounds.
Okay. At tomorrow. Tomorrow.
Okay, please. Otherwise,
You bring with your be ready with your judgments,
My-
all these points. Yeah.
My lord, only one thing, my lord. There is no scope of improvise. They cannot improve their case. Well, what it
Oh,
has.
yes, see, Mr.
My lord.
Pusha, under 482, we will see what the complaint is.
My lord,
Nothing more, nothing less.
my lord,
That's all.
my lord
We
will
cannot go to
examine-
your defense, we cannot go to his defense. If no case under section 138 is made out, it will be quashed. If it is made out, it will be,
Yes,
your
ma'am.
petition will be
Yes,
dismissed, that's all.
Yes, my lord.
And we, as per my limited knowledge, I understand what is to be considered in exercise of power under 482. We cannot enter into the factual defense.
I'm not.
Yes, no, your first argument was that only, that this is my defense, I have filed suit, what not.
My lord.
Yes, next tomorrow.
All right.
tomorrow 10:30.
We cannot assure anything,
Not.
Mr. Counsel. If you can manage, you will be here. If you cannot, we will proceed. That's all. Yes.
So this is an application under 102 of the Juvenile Justice Act. I have invoking the revisional jurisdiction, Lordship.
Ah.
My complaint was, police submitted a final report against that. I filed a Naraji petition that, but the matter was closed. The court would have allowed me to proceed as a treating the same as a complaint. That is the only grievance because my grandsons died when they went out with the private respondent, Lordship.
Where is the what is the issue here?
The Lordship will find my page 11.
Page 11.
Because post-mortem was performed after 3 months and the report says it was in a decomposed state, so nothing could be ascertained, the cause of death. Of course, there was a delay in lodging the FIR.
You are, who are you?
I'm the grandson of the victim. I'm the grandfather of the victim. My grandson went along with the private respondent.
Your grandson went along with the private respondent. Somebody informed that they were bathing. Then your grandson died. Now this person was named as accused. Now what is your grievance? He is accused.
The police has submitted final report and that accepted by the land court bill. I filed a Naraji petition that was dismissed and the court said that I should go and file a fresh complaint petition. The court would have treated that, Lordship. That is the only grievance. That is what.
Court could have you also.
Lordship, that is what has been stated in. Lordship.
But three options with the magistrate. First is to accept the FR. Second is to not to accept, take cognizance. And third is to register is further investigation. And fourth is to convert into as a complaint.
He could have done that.
Still you are insisting. This child gone together for bathing. Both were minors. Both were juvenile.
They are juvenile. They are also juvenile.
Both juvenile. They went for a.
And the victim compensation, if that is ordered, Lordship, I can that because one has gone, let's 3 other may not suffer for that.
Postmortem could not be conducted because in the,
It was in a decomposed.
it was in a decomposed state. The body was exhumed,
This is basically an emotion.
and the petition
course.
which they have filed, Lordship, it consists no ground whatsoever. Just
Where is your
4-5
petition?
line petition
Where is
that
your-
also has been observed by the learned court below. That Lordship will find at page 39.
Okay, let him have a satisfaction. We'll see the case diary.
Plus.
Okay, go through it. Give the statements investigation. Where is the complaint? This is
Lordship complaint is page 11, and the Naraji, if the Lordship is asking for the Naraji petition, that is at page 39. Before that, Lordship, may kindly come to the FR. Page 35.
page,
Page 35, this report fully stated that
page 35.
the actual date of the could not be ascertained because of the time of performing the postmortem, the body was in total decomposed condition.
Just a minute.
Correct, it's more of a emotion, Lordship, and 10 years by now, Lordship. Under the scheme, some victim compensations amount has been paid, Lordship. I think that will be
Heard. Mr.
Speak about
Chakraborty,
it only.
learned counsel for the petitioner also has a bench of bench. The present application
only one observation made.
uh,
I've marked that portion.
is filed under section 102. Magistrate direct reinvestigation.
All the options that has been discussed. We have treated the Naraji petition
Huh?
in.
Further investigation, and there is a difference of reinvestigation. So I think this has been subsequently, law was clarified that reinvestigation can be or de novo or by an independent authority can
Or he
be
could
done
treat my,
on only by the higher courts, constitutional court, not by magistrate.
Or he could have treated my Naraji into a pursue with as a complaint.
Therefore, we going to the merit. I have seen nothing is there. So therefore dismissing.
Suggest that none of the witnesses which statement were recorded, but none of them have implicated any of the accused persons.
Mr. Swenchel, this is an application under section 102 of the Juvenile Justice Care and Protection of Children with bracket close Act 2015, read with section 482 of the Code of Criminal Procedure. By this petition, the petitioner has challenged an order dated 5/1/2017 passed by the Principal Magistrate, Juvenile Justice Board, Udalguri BTAD, accepting the final report of the police and thereby setting the accused at liberty and rejecting the objection raised by the petitioner. Full stop. Present application was filed under section 482 of the Code of Criminal Procedure for quashing of FIR dated 17/2014, registered as Abhayapuri PS case number 62/2014 under section 489. 489, 498. 498A/34 IPC. As no interim order was passed by this court while issuing notice of motion way back in the year 2014, and as none appeared for the petitioner on call when the matter was listed on 22/11/2024, this court requested Mr. B. Sharma, learned additional public prosecutor, to obtain instruction as regards the present status of Abhayapuri PS case number 62 of 2014. Full stop. Mr. B. Sharma, learned additional public prosecutor, has obtained instruction from the IO and submits that the investigation has already been completed and a charge sheet has been filed being
Charge sheet number 38 of 2014,
38 of 2014,
dated 27/3,
dated 27/3,
2014.
Full
Fine.
stop. In absence of any challenge to such
Fine.
sheet, in the considered opinion of this court, nothing survives to be adjudicated in the present matter. Full stop. Accordingly, criminal petition stands closed. Interim order. Oh no, there is
No,
no.
no,
interim.
no.
That's yes, Mr. Sagrabati, you want to say?
This case I was engaged by the council, thus he is no longer in practice. The brief is not along. I was gone through this lottery. It's only 5,000 has been cost that has been exposed, so modified in the appeal. I think that will be enough for him to. And I don't know whether the man, perhaps by this time he must be of 73, 74, whether he is alive or not. That is also
This is appeal, criminal appeal.
revision, because
Madam.
appeal was modified.
What was the punishment?
354, punishment was 6 months and paid to pay fine of human husband.
Well, initially it was simple imprisonment for 6 months, my lord, and fine of rupees 5,000, court below. And thereafter in
Modified.
appeal it was modified and only 5,000 imposed.
I think that will be.
That is,
Now what is to be done?
my lord, that is already from the evidence, my lord. If we
Materials
put
are
it
there.
My lord, materials are there, my lord. PW on
Only fine.
only fine, my lord. Only 5,000 rupees they have to pay it, my lord, to the victim, my lord.
Heard, Mr. You record your name. Heard, Mr. Sagrabati. Learned. See how you are spending time.
My lord, only
Precious
for-
judicial time. Huh? Anyway, we'll have to finish it one day. Heard, Mr. Sagrabati, learned counsel for the petitioner. Also heard, Mr. Sharma, learned recent publication. The present application under section 482, 397/401 CRPC, read with section 482, is filed assailing judgment and order dated 12/8/2011 passed by the learned additional session judge Kamrup in criminal appeal number 42/2009, by which the conviction and sentence passed by the learned Chief Judicial Magistrate Kamrup in GR case number 3737/2005 dated 9/6/2009 was modified, and the petitioner was directed to pay fine of ₹5,000 only, and in default of payment of fine, simple imprisonment for 2 months, inasmuch as the learned Chief Judicial Magistrate, while convicting him under section 354 IPC, sentenced him to undergo simple imprisonment of 6 months and also to pay fine of ₹5 lakhs, 5,000, and in default, simple imprisonment for 2 months. 2 months. Any else here?
Yeah, madam. LCR is here, madam.
Ah.
I have checked, madam.
come on.
PW1.
The brief fact of the prosecution case is that on 26/7/2005, an FIR was lodged before Nunmati police station by the victim, alleging that on 23/7/2005, while she went while she went to her place of her mother, accompanied by a boy, to the clinic of the petitioner to get her horoscope
Right.
examined.
Astrologer, madam.
To the clinic of the petitioner to get her horoscope examined. And in the name of examination, she was taken to inside room, and petitioner has outraged her modesty by putting hand in her private parts. Full stop. Accordingly, Nunmati PS case number 186/2005 was corresponding to GR case number 3737/2005 was registered. Full stop. After completion of the investigation, charge sheet was filed under section 342/354 IPC. Full stop. During the course of trial, the prosecution, and as the petitioner pleaded not guilty, the trial commenced, and the prosecution, to bring home the charges against the petitioner, adduced 4 witnesses. 4 witnesses. Full stop. The petitioner was examined under section 313 CRPC, and
one DW was also there.
one defense witness was also examined. After conclusion of the trial, the petitioner was convicted by judgment and order dated 9/6/2009. Was convicted to undergo, convicted under section 354 IPC, and was sentenced to undergo simple imprisonment of 6 months and to pay a fine of ₹5,000, and in default to undergo further imprisonment of 2 months. Full stop. Being aggrieved, the petitioner preferred an appeal which was registered as criminal appeal number 42/2009, and the learned session judge Kamrup Guwahati, by judgment and order dated 12/8/2011, though affirmed the conviction, however, modified the sentence to pay a fine of ₹5,000 and in default to undergo imprisonment of 2 months. Full stop. Mr. Chakraborty, learned counsel, referring to the evidence of PW, evidence of the victim, argues that there is material contradictions in her statement, and from her statement, nothing is discernible even to remotely suggest any offense of section 354 IPC. However, both the learned trial courts below has committed perversity in relying on such evidence and convicting the petitioner. Full stop. Per contra, Mr. B. Sharma, learned additional public prosecutor, submits that both the trial courts below has concurrently held the petitioner guilty of committing offense under section 354 IPC, inasmuch as the evidence of the victim remain unshaken and therefore this court, in exercise of power under in exercise of its revisional power, may not interfere such concurrence findings of fact. I have given anxious considerations to the arguments advanced by the learned counsel for the parties. Full stop. It is true that object of revisional power of this court under section 397 or 401 is to set right a patent defect or an error of jurisdiction or of law. Such power can be exercised where the decision under challenge are grossly erroneous, there is non-compliance with the provisions of law, the finding recorded is based on no evidence and the material evidence is ignored, or judicial discretion is exercised arbitrarily or perversely, or such decision has resulted in miscarriage of justice. In view of the taking note of the aforesaid settled proposition of law, this court has also perused the evidence laid by the prosecution, more particularly for the reason that the learned counsel for the petitioner has asked that there is perversity in such finding. Full stop. The victim was examined as PW1. And she has described in her evidence how she went to the place of the petitioner and how the accused tried to outrage her modesty. According to her, in the name of treatment, some oil were poured in her nose and the door was kept closed. And there after pouring the oil, the astrologer asked her to touch his body, and thereafter he undressed himself and also asked the victim to open her clothes. She also alleged that he has touched her body, touched her private part. During cross-examination, she has affirmed that though she has not written the FIR, however, the FIR, she read the FIR. During cross, she has reaffirmed that the accused person, touched her private part. She has denied that she has falsely lost the case. She was candid in saying that she also visited earlier. However, the accused did not misbehave with her on earlier occasion. Full stop. Okay. From such evidence, There is nothing to there is nothing to disbelieve or suggest anything that the the victim has falsely deposed before this court, inasmuch as her deposition remained unshaken during the cross-examination. Rather, certain facts of rather the conduct of the accused inside the room was reaffirmed by her. Full stop. In such a situation, there cannot be any eyewitness, inasmuch as law is well settled that in such a case, if the victim's evidence is of sterling quality, a person can be convicted on the basis of sole testimony of such victim. Full stop. Therefore, in the aforesaid backdrop, this court is in total agreement with the findings recorded by the learned courts below, which are based on sound reasoning. In the considered opinion of this court, and as discussed herein above, the learned court below has duly appreciated the evidence on record, and conclusion arrived at on the basis of such appreciation of evidence cannot be termed as a decision, cannot be termed the said decision as a perverse decision. Accordingly, this court finds no merit in this revision petition. Same sense dismissed. LCR be returned back.
Also payment made within period of ballot.
And that they will do. Otherwise, he will go to jail. It's up to him. In view of the order passing so and so, the miscase stands closed. Item number? None appears for the petitioner on call. Appellant on call. It is a criminal petitioner appeal. This is what a councils. None appears for the petitioners on call. Considering the nature of the litigation. Considering nature of litigation, let Sri Pritam Mohanta, learned counsel, be appointed as amicus in this case. Registry to furnish the relevant papers to Mr. Pritam Mohanta and to list this matter on, give a date next week in the orders column. 29th in the orders columns, reflect the name of Mr. Pritam Mohanta as amicus. Election petition reference na kaya tutar nahi. Yes, Mr. Chaudhary.
Yes, my lord. Here, my lord, in the instant case, my lord, it was alleged that one accident took place, my lord, and I was, my lord, convicted under section 279-304A of the Indian Penal Code, my lord. For the 304, I was punished for 1 year, my lord, and 279, my lord, I was punished for 3 months, my lord. Basically, my point of argument is that, my lord, that accused was never identified in the dock. First point. And no one has seen the accused person has dived the vehicle. If you also go to the evidence, my lord.
Okay, let us see who are the eyewitness projected by the prosecution.
Yes, my lord. I am coming, my lord. Next point, I am discuss first point, my lord.
Okay.
Then your lordship will one after another, my lord. The allegation is that the offending vehicle was driving in high speed or excessive speed. That is the allegation, my lord. My humble submission, high speed does
No,
not.
no, it will be race and negligence.
There must be
Some material to say that it is
say-
race and negligence. Only high speed will not always
there, my
mean.
lord. That, my lord.
Yes.
Third, my lord, my point is there, my lord. No, any witness had said that, I have already said, that petitioner is riding the vehicle. Third, my lord, the driving license, that has not been produced before the court, my lord, to show that I am the driver of the particular vehicle, my lord. Fourth, my lord, the prosecution case should be stand their own legs. But basically, the person was convicted on the 313 statement and defend witnesses, my lord. Fourth, my lord, 313, all the questions were not put, my lord. That is the case, my lord.
Yes.
And my lord, fourth is, my lord, is evidence that the particular girl is crossing the road, my lord. It is the evidence, my lord. But that was not considered, my lord. I am coming, my lord. First, my lord, witnesses, my lord. First, your lordship, kindly go to the PW1, my lord.
So once race and negligence is gone,
Yes, my lord.
then 304 is also
my
gone.
lord. There is no ingredient, my lord. Subject to
What was
correction, my lord.
279?
279, if the accident occurred, my lord, then, my lord, that is 279. And 304A, if he has died, culpable, not amounting to
Now
murder.
279, what are the ingredients?
Yes, my lord. And yes, my lord. 279, my lord.
So suppose we hold that there is no rest and negligent driving. Why should we go to all other points? Please tell us first that.
Yes, my lord. This is correct.
You
Rash
will not go to others. Let
yes,
us
my
see
lord.
first the
Rash driving in writing of a public way. The ingredient of rash and negligent driving both is available in 279 as well as 304A.
Yeah.
If your lordship go through the evidence, subject to correction of my friend, there is no one has said I was rashly and negligently driving the vehicle. Ocular evidence. my lord.
Yes, tell us.
PW3,
Mm.
PW5,
Mm.
and PW6.
Mm.
They have stated that they were outside their houses
Mm.
and the accident took place when this girl,
Mm.
on the other side, her mother is there and other persons were also there, and she was in the other side.
So she crossed the road.
She is just trying to cross, Lordship. This vehicle came from the side of the, I forgot the direction, Lordship. But when she want to cross the road, this person came by rash and negligently and hit this girl.
Let us see the evidence of
Yes,
PD.
my lord. PW3. I am reading now.
Please read it.
My lord.
Where do you get that? Please.
Page 10 of the paper book.
Paperwork is there.
Yes.
So beautiful. In a rash and negligence.
Actually, I
Because you where Mr. NNB Chaudhary is there, even in these cases you get a paperwork. See the beauty of having Mr. Chaudhary to
I have prepared the paper book thereafter I have given. Thereafter.
think of it. This should be the spirit. Nobody is doing that.
Yes, my lord.
PW?
About 3 years ago.
I think you should get acquittal only for preparing the paperwork. PW?
PW3. About 3 years ago.
Just a minute. Pace. Who are the eyewitnesses? Please tell us.
3, 5, and 6.
3,
6.
5, and 6. Pace
Other one there,
10,
no?
12, 13.
Otherwise, he has not said. I am reading his witnesses, my lord. Father of the deceased. About 3 years ago, 5-6 p.m., myself, Anjita, Raskar came back from Namgal. We're taking in front of the house Anjita. At the second approaching to me, almost reached me. We were standing in the extreme side of the road. At that time, a rice loaded truck coming from Lakhimpur side, Dhemaji, in excessive speed knocked my driver. She was bifurcated 2 parts and the spot. After the incident, driver was used brake, who caused huge sound because of the truck in excessive speed, and driver, after committing the action, tried to flee away, village of Kodhol, driver and handle of the driver. I have not seen the who drove my truck. That line also important, my lord. And
Then PW?
2.
PW3 you have read?
Sorry.
PW3 or 4? 3. We have read 3.
Yes, ma'am.
Then we'll go to.
My daughter reached me and was standing extreme side of the road. where
Okay,
the
now
accident-
PW5.
Yes, my lord. PW5. PW5. I know Vishnupuram Phukan so relative, my neighbor. The incident took place case 12, my lord. It's a 806 at 5:30 p.m. NS. At that time, I was working in front of high. During the truck came from my side in excessive speed from the coming Lakhimpur. It was on the right side of the road where the mother second Anjita Ruskar talking and the truck knocked down. She bifurcated 2 parts on right on the spot and the drive of the right away fled. But we are nearby the people called the driver. The driver of the truck was Tulku Bahadur Lama. Truck was stopped on the spot. We informed the police went to the body of the victim. Truck, including the truck was overloaded rice. Police examined. Police is in present. Exhibit 1 is the seizure list. After the incident, driver tried to flee away. Only I saw the driver.
Then PW?
I agree. 6. What?
6.
6. I know Baram Phukan relative neighbor place. Usual matter. A daughter of Vishnuram Phukan Anjita Kuar, where the right truck came from Lakhimpur excessive speed. Thereafter big sound. I turned toward the place. Sound saw the truck knocked down. He died the spot and the accident rider flew away, apprehended the police extremely. I have seen the driver of the truck. I can recognize being seen him first time when he tried away from the incident. The incident, Lasith Shankar, he has not mentioned the name of the
Others
driver.
may be there also, Lordship. I cannot go through, Lordship.
Who are the other witnesses, Mr.?
I'm reading one by one, my lord.
No, not necessary. Who are the
Seven.
eyewitnesses?
Eyewitness মই অকল সেইকেইটাই পঢ়িছো, বাকী মই পঢ়িব পৰা নাই।
I have taken C. Kunjal, PW3, PW5, and PW6 are eyewitnesses. Any other eyewitness?
Yes, sir.
Which are?
That my lord PW7, I feel what was allowed.
PW7.
Yes, my lord. I know the relative. Lasit Sangha, at the time, below Lasit Sangha, I saw a truck was coming from the excessive side knockdown. Shankar was talking with her mother and Anjita right side of the road. Selcom Body bifurcated and died on the spot. The driver of the truck, after the incident, tried to flee. The local came handed over to me. I have seen the driver, he got down the truck but I have not seen the driver while he was driving the truck. I was present near the place of I was witnesses occurrence to my own eyes.
But you have no suggestion that that second point I have not been identified. You also not says that I was not driving.
Yes, ma'am, I see.
Where is that suggestion?
Ma'am,
Cross examination?
313 I can say.
313 you have said.
Yes, my lord. I have categorically stayed in different witness also I said. I have given DW1.
But this person was caught hold in the place, Lordship.
My lord, preponderance probability, my duty is to prove that there is a preponderance probability that I may not be driving the vehicle. The duty of the prosecution to show the case has been proved all reasonable. doubt.
See, prosecution evidence says it is on the national highway.
Yes, my lord.
Do you expect a national highway vehicle to come in a slow motion? It was in a speed. Admittedly, it's a national highway. And admittedly, we are standing in the side of the national highway.
Cross the road, mother has said.
Mother's evidence is PW?
PW3, page 10. Said road at the time Rastoke from Lokhimpur.
Page 10, page 10. No.
Dota and CS Baker. At the time of accident, driver used the brake, truck was excessive speed, driver committing the accident. Raskor from Namgar, we are talking Anjita at the time, was approaching to me.
Where?
First, third line, my lord.
About
Okay.
Namjita Raskor came from the Namghar.
Second is the deceased.
Who is Anjita? Ananjita Raskor.
Anjita Raskor.
And we're talking in front of the house of Anjita. And
Yes,
at
sir.
that time, second was approaching to me and almost reached me.
Yes, my lord.
And we were standing on the extreme side of the road.
Yeah.
And at that time, rice loaded truck coming to the Lakhimpur side towards Dhemaji. Okay. Yes, public prosecutor. Judgment.
Excessive speed. like this.
So us.
Thank you, sir. Yeah, I do. क्या मैं जीतू कुछ इतने दिया ना तुम यार Para 4, my lord, of that judgment, my lord. Para 4. Merely because that was being driven high speed does not back either negligence or rashness. None of the witness examined by the person give the indication even approximately as to what the high speed. High speed is a relative term. This was the prosecution on being record material to establish to what mean high speed.
Heard Mr. NNB Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. The present application, IPC, present application. NNB Chaudhary, learned counsel for the petitioner. The present petition under section 397/401 read with section 482 of the Criminal Procedure Code 1973 is filed assailing judgment and order dated 20/06/2011 passed by the learned Session Judge Dhemaji in Criminal Appeal number 801/2011 arising out of judgment and order dated 25/1/2011 passed by learned Judicial Magistrate First Class Dhemaji in GR case number 317/2005 within bracket DMJ, thereby convicting him under section 279/304 capital A, IPC, and sentencing him to
Sentencing him to, my lord, under section 279, 3 months,
sentencing him to undergo
279, 3 months, and
uh,
304A.
undergo sentence of 3 months for the offenses under
279.
section 279
And-
IPC and to suffer
And to suffer imprisonment for another 1 year. For the
and to
offence under
suffer
section
imprisonment
304.
for simple imprisonment for another 1 year for commission of offense under section 304A IPC.
IPC, all the
And
sentences concurrently.
on default concurrent. The aforesaid sentence were to run concurrently.
In
Mr. Chaudhuri, learned counsel for the petitioner, contents that counsel for the petitioner contents that the contents that the both the learned courts below has committed error of law. And the decisions, both the decisions are perverse in as much as there is no iota of evidence to suggest either to the effect that the petitioner was driving the offending vehicle, or that even if he is driving the vehicle, he was driving it in a rash and negligent manner, except deposing that he was in a high speed. Nothing is discernible from any of the eyewitnesses to suggest any rash and negligence driving on the part of the petitioner. And therefore, according to Mr. NNB Chaudhuri, learned counsel, such judgments are liable to be interfered in exercise of its by this court in exercise of its revisional power. Otherwise, same will result not only in miscarriage of justice, but same will miscarriage of justice. Full stop. Per contra, the learned additional public prosecutor, Mr. Swensur, argues that from the evidence of the eyewitnesses, it is clear that the offending vehicle was being driven in a very high speed, and the victim was in the right side of the road. Therefore, even though there is no specific deposition as regards rash and negligent driving, such factum itself establishes beyond any reasonable doubt that the petitioner was driving the vehicle in a rash and negligent manner. And therefore, the learned trial courts has rightly passed the judgment. And this is not a fit case to exercise this court's power, revisional power in the given facts. I have given express considerations to the arguments advanced by the learned counsel for the parties. Also perused the materials available on record, including the statements / depositions of witnesses before the trial court. The prosecution has projected PW1, PW3, PW5, PW6, and PW7 as eyewitness to the accident. From their deposition, what is discernible is that the accident took place at about 5:30/6 p.m. on 8/6/2005 at National Highway 52. The evidence of the eyewitnesses further suggests that the vehicle was in a high speed. The evidence of PW1, the murder, further suggests that her daughter was knocked by the vehicle at a point where she and another person was talking near the road, and the victim child was coming towards her. Full stop. Law is by now well settled that it is the prosecution who is to prove rash and negligent driving. Who is to prove the rash and negligent driving? And same is to be proved by clear and credible evidence. There can be two kinds of witnesses which can be treated as a credible witness in such nature of a case are the eyewitnesses and the physical evidence from the site of the accident. In the case in hand, it is equally well settled that high speed alone is not enough to prove rash and negligent driving. The circumstances and context surrounding the driving behavior are important. In a given case, driving at a high speed or low speed does not necessarily mean that the driver acted rashly or negligently. In the case in hand, as recorded herein above, none of the eyewitnesses has stated regarding any rashness or negligence on the part of the driver in driving the vehicle, except stating that he was in a high speed / excessive speed. The fact remains that the accident took place near a national highway. Therefore, in the aforesaid circumstances, there ought to have been some material to suggest certain acts or omission which can be proved on omission on the part of the driver, which can be shown or proved to be negligence or rashness on his part, more particularly when the vehicle was being driven in a national highway. Therefore, in the considered opinion of this court, both the learned court below has failed to consider this aspect of the matter, and this aspect of the matter resulting in patent defect in the judgment, inasmuch as the law settled in this regard has been ignored by both the learned courts below. That being the position, this court is of the view that this is a fit case where this court should exercise its power under revisional power accordingly, ordered accordingly. And accordingly, the impugned judgment that it's so are interfered, set aside, and quashed. The accused petitioner is discharged. Anything to be added?
Husband, my lord, Judicial Magistrate 25/1/2000.
That we have dictated.
Yes. And Session Judge, my lord,
That will
26. Yes.
She crossed the road. Truck was coming. Both were talking. What to do? National highway. Yes.
As
23, what is
Minor.
the statement of the victim?
my lord, victim statement is there, my lord. PW1, my lord.
And second,
My lord, answer from my lord.
any medical evidence?
Medical evidence, my lord. That's
LCM.
by a doctor, not a.
It's to be done. If we appeal this, a person will be convicted. Nobody is here.
Right.
How many amicus will
Yeah,
appear?
perhaps in the last two occasions, there are
Last
not.
occasions, nobody is appearing. We'll consider this to be misconduct on the part of the lawyer. We'll send it to the Bar Council.
Initially, it was under section 307, 387, 506, 34. The term conviction was done on only on 326 IPC. RI for 6 months.
There is no scope of review also in a
Right, right.
criminal
Hmm.
case. Who is PW2?
EW1 is big.
Eyewitness.
My lord, some of the, my lord, they are in petrol pump, my lord. Employee of the petrol pump, my lord.
No, he's arrive at the place immediately.
My lord.
He's not medically examined or what?
My lord, medical officer also I have not found, my lord, whether he was examined or not.
He is the only man who says that I was done like this. He has not said any injury, nothing of that sort. Isn't it? He
Right.
said somewhere I had pain and all. So he was not tested. How will you decide this issue that? Can we say that prosecution has established beyond all reasonable doubt?
From the evidence of BW1 court also
PW1 is there.
conclusion, my lord.
It's an injured witness.
Came to the conclusion, my lord, that some injuries are there.
None appears for the petitioner on call. None did represent the petitioner when the matter was called. When the matter was called on 12/6/2020. No, when the matter was called on 26/7/2012. And 12/6/2022. In view of the aforesaid, Mr. M. Dr. Minmoy Dr.
Right.
Learned Counsel be appointed as an amicus in this case,
Right.
registry, to furnish him the necessary papers of the appeal, necessary papers, and list this matter on next Tuesday or orders, list this matter on 29th in the order columns reflecting name of Mr. Minmoy Dr. Next week, okay. Okay. 5th. Yes.
Fourteen. 11, I mean, 11.
Yes, call then next one. 12 was adjourned, I think.
12.
Okay, at least request was made. Okay, we'll adjourn this. When give a date. On the prayer of the learned counsel for the petitioner, list this matter on December 2012 matter. We thought that by end of this
My lord.
year, we'll at least come to 2015,
15.
10th of December. Yes, ne?
I mean, no. 14.
None appears for the petitioner on call. Mr. Talukdar was appointed as amicus. He is also not here. What is to do? We ourselves will become amicus. The present application under section 397/401 IPC 401 read with section 482 of the Code of Criminal Procedure is filed, assailing a judgment dated 9/12/2011 passed by the learned Principal Judge, Family Court, Kamrup, Guwahati, in FC Criminal Case number 248/209 under section 125 of the Code of Criminal Procedure. By the aforesaid order, the learned Principal Judge directed the petitioner to pay rupees 1,500 per month to the respondent from date of passing the judgment. The brief fact is that the aforesaid case, i.e. FC Criminal Case number 248/2009 under section 125 of the Code of Criminal Procedure 1973 was preferred by respondent The case of the respondent as projected was to the effect that the respondent and the petitioner got married as per Hindu rites and rituals, and thereafter they lived together at the residence of the petitioner. However, after few months of their marriage, few days after marriage, the petitioner started behaving cruelly with the petitioner, with the respondent wife. Full stop. Also, it is also alleged that there was a miscarriage due to torture due to physical and mental torture upon her. And there was a miscarriage at 1.5 months of pregnancy due to physical and mental torture meted upon her. It is also an allegation that Harvan was an addict and he was admitted to a home for his treatment. And accordingly, she was compelled full stop. It is also alleged that though the petitioner is a government servant, he has neglected to maintain the respondent wife, and the respondent wife did not have any source of income to maintain herself. And due to the cruelty meted, she was to live separately. The case projected by the petitioner is that the denial of any torture upon the petitioner, compelling her to leave the house. Though the marriage has been admitted. After consideration of the material available on record, the learned principal judge the material available on record also suggests that the respondent wife also filed a complaint case being 7792C/2007 for return of Stridhan, which was also dismissed by the learned Chief Judicial Magistrate on 29/4/2009. It is also on record that the petitioner instituted an application under Section 9 of the Hindu Marriage Act 1955 for restitution of conjugal rights before the Court of Learned Principal Judge Family Court. According to him, to counterblast such petition, the application under Section 25 CRPC was filed. It is also on record that the respondent wife filed a suit for decree of divorce being FC civil case number 635/2010, which was disposed of in Loco Adalat by an order dated 9/11/2010 on the basis of a settlement arrived in as much as the in as much as they withdrew the earlier cases, withdrew the earlier case of restitution of conjugal rights. Accordingly, marriage between the parties were dissolved by way of a divorce on mutual consent, as per the terms of confusion mentioned in the joint petition. As per the application on the basis of which the decree of divorce was passed, reflects that the parties have agreed to divorce under mutual consent, and the husband has agreed to return the Sridhan. In the aforesaid backdrop, the present application was filed for quashment. Yes, Mr. Bhuya, have you heard what I have dictated? Please come forward. Apparently, 125 was there, and there was return of Sridhan was there, and a divorce petition was also there. Now, in Loco Adalat, it was settled that they will be mutually dissolve the marriage. Marriage was dissolved. Only condition was that Sridhan will be returned, but there is nothing to suggest anything about 125. Marriage is dissolved. Now 1500 is given. How can we interfere in this? Or who we should intervene? What to do? Nobody is here. We cannot dismiss it for default also.
125 would be a separate proceeding.
Separate proceeding. So even if it is sees that the marriage is dissolved, there is an order. And in the decree of settlement, there is nothing that this will be alimony or this will be maintenance. Nothing is there.
Even there is a decree also with regard to there is no condition of paying maintenance. So after that decree, if it's been financial constraint with regard to the lady, even then she can
come. Full stop. From the aforesaid, most probably they have settled.
Maybe.
At least they could have come and said it. Now it will be a headache for the husband. Now he will pay. The warrant will be issued. We cannot review.
That's true.
Isn't it?
Yeah.
This is the difficulty sitting in this bench. They think that we have resolved. Why should we bother to already case is filed? And by mandate of law, we cannot dismiss it for default. If we cannot dismiss it for default, we can appoint an amicus. Amicus cannot enlighten us on facts.
Horse's mouth.
Full stop. This court is of the view from the perusal of the application as well as decree of this application filed before Loco Adalat as well as decree of the dissolution of marriage passed by the Loco Adalat. suggests two things, that the Sridhar suggests the settlement between the husband and wife to the effect that the Sridhar will be returned back to the wife and the marriage will be dissolved. However, there is nothing to suggest that any permanent alimony will be paid on dissolution of the marriage, or that the husband will not maintain the wife after the dissolution of the marriage. Full stop. In view of the aforesaid, this court, in absence of the counsel for the petitioner and respondent number 2, cannot presume that the matter has amicably been settled, and this court also cannot interfere the reasoned decision of the learned principal judge family court on this count. Therefore, this court has gone into the impugned judgment as well as the material available on record. From the evidence and material, it is seen that the respondent has been able to establish that the petitioner husband was having sufficient means, and that the respondent wife was unable to maintain herself, and she did not have any sufficient means to maintain her. In view of the availability of aforesaid evidence, this court is not inclined to exercise its power, exercise its revisional power and or inherent power to interfere with the decision of the learned principal judge family court, inasmuch as such decision cannot be said to have any patent defect or an error of jurisdiction or of law. The evidence on the basis of which after perusal of the evidence on the basis of which the decision was arrived at, this court is of the opinion that such decision is a well-reasoned decision and cannot be termed as a perverse decision. In view of the aforesaid, present revision petition stands dismissed. Full stop. While parting with the record, it is, however, made clear that the parties shall be at liberty to approach the learned principal judge family court under section 127 CRPC if there is any change in the situation, and in the event such application is filed, same may be considered as per law. Yes, what is this? 14
Negotiable instrument.
negotiable. Swear 2. Okay. But within 15 minutes it will not be over.
It will be over.
Dictation will also be over.
I think so, my lord.
Can you also fix a date, by the way?
Yeah, 2.
Why not? I've got some personal difficulties.
Okay, what is 15?
So, actually, what happened in this case, my lord, that he
Pay him. You have mutual settlement.
completely admitted.
We have enjoyed for 2012.
Absolutely.
Enough.
Not let it come day after tomorrow. I will do it.
Okay, day after tomorrow.
No issues.
Okay. Day after tomorrow, how many hearing matters are there? It will not take much time. Revision. It is revision, isn't it?
It's a question of security, whether it is a security or not.
Security or not. Okay.
Because he has admitted that is
3rd of December.
not against life.
Give it. Day after tomorrow.
No issues.
Okay.
Simply obliged.
We don't want to keep it that way.
Yes.
It's better. Then you can have good cases to be decided early.
Absolutely.
You'll have to clear the clog in the artery.
Yes.
Then only heart will beat. So that is now my responsibility to clear the artery. Yes, next.
Obliged.
Yes, Mr. Kotoki, what is 15 and 16?
15 my person died, my lord.
Your person died. And what about 16?
My lord.
You draw. Okay. Okay. So we'll close it.
May I please
being
have
abated.
my se-
Other person, I think they are.
No, that see, there is some
my
adjournment process.
senior, the CBI
Chakraborty, P. Chakraborty.
no, M. Haloi.
M. Hallo is CBI.
He is in Lex. He's in court number 19, Lordship.
So let him be in lake for 19 because there was an prayer made that P. Chakraborty is there with brief is in withdrawn. So we'll engage somebody in as an amicus. Now what? Can we close your case?
My person died, my.
So abated.
Abated.
Okay. Mr. P. Kotoki, this is an application under this the present appeal in right item number 249.
Chandan Borua, my lord.
Chandan Lal Borua.
Chandan Lal Borua.
The present application is filed assailing judgment and order dated so and so, so and so, so and so. Full stop. It is submitted by Mr. P. Kotoki, learned counsel. Any verification is required?
Lordship, I'm not aware of this, Lordship.
Any verification required?
Let him verify.
Okay, submits that the appellant has in the meantime expired. Any date?
The death certificate I've given in the file.
Okay, give the file. Give the file. Death certificate. We asked Mr. that he may be granted some time to obtain instruction in this regard. Okay, what about what? Because he will adjourn us item number 16, no doubt about that. We'll appoint some amicus. You may not be, need not be here. If any report is there, we'll close it. Okay.
Lordship, my humble prayer, my senior will come and argue this matter. I'm not aware of
No,
it.
will not allow him to argue.
I'm not aware of this. I
No.
fear for any default on my part.
No, you cannot be. Even you are a lawyer standing there, you must be aware of your brief. Okay, at 2.
Deeply obliged.
At 2. How many matters are left? But why 11 is left? Give a notice that we want Mr. BD Das at 2 in this court. So only left is item 11 and this and 15 and 16 that will be so PP is free or 11 is there.
11, we are not here.
11 is there, isn't it?
Fine, 11 is there. PP, state is not party here.
Okay, this is CR, I think CR
Minor,
most
yeah.
probably. We'll see that. We'll call BD Das and S Gogoi. Who is S Gogoi? You say BD Das, N Goswami, HK Sharma. Don't call BD Das, he's a senior advocate. Call N Goswami and HK Sharma. And S Gogoi at 2. Notify.
Before your logic check, I check the file. I think doesn't make any difference with the signature. One. Secondly, the checklist which my learned friend has shown, checklist contents of the stamp.
The reporter
Reporter signed it,
Not that, not
and I have tell it. Maybe, I don't know, there is always when you sign my or a signature,
Yes,
there
in
is a
fact,
slight difference.
my own signature.
Yes,
In
it
fact,
very-
there is a record of returning my check to be
Not-
not telling with the signature.
Yes.
And nowadays we don't have any
I-
habit of
I
writing.
have changed my signature, made it very simple. Earlier, my signature
That
was
is what I
simple.
am trying to do it.
Earlier, my signature was very long this way. Then a story has happened. I went outside. Then they were not releasing money. So it's not your how its signature differs.
Same happened to
Not
me.
once. 15 times I tried. Then I
Cannot-
thought that I'll change it, my signature. So I think, my lord, without wasting any time, we should withdraw this case.
Okay,
I
you-
told my learned
Okay,
friend.
you withdraw. We are
And-
granting you time
Yes.
to file
to
written
file written-
statement.
Let it be a time given to file a written statement.
Or if
and
any application you
Any
file, that's up to.
application will.
We are not commenting
Yes,
anything.
Yes.
That's all.
I'm sorry for troubling my.
No, this is not a trouble.
My learned friend, because election, what
Now
I
this
thought-
file will carry this with me, whether I go
Yes.
there or here. Otherwise, it is very difficult. In which one, which petition?
In 197, 198.
198. Mr. D. Das, or Mr. D. Das, learned senior counsel, assisted by Mr. Swenso Das. Mr. Das, in his usual fairness, submits that though this application was filed under section 86, read with section 81 of the Representation of People, section 1951. However, after going through the original record, he has not found anything to pursue this matter.
Yeah.
Accordingly, he submits that this matter may be IA may be
Application
allowed
line.
to be withdrawn.
Yeah.
However, he submits that the time earlier granted to file written statement may be extended. Full stop. Mr. Singh, in his usual fairness, has not objected for grant of time to file written statement. Accordingly, IA stands closed. IA stands closed on withdrawal. However, it is provided that, however, the petitioner, in terms of this court's earlier order, where is that order?
Yes, that is, yes. 197, your lordship.
Okay,
has got
okay,
them.
okay.
197.
Okay. We are keeping this in view of the earlier order passed in 197
197.
AP 2024 dated
11.
dated no, the earlier order as people last time order passed and Swensu, and in view of the withdrawal of the present application, the time for filing written statement is extended till
Yes.
the next date fixed.
Yes.
Give a date.
30 days, can it be 30 days?
Yes.
Yes.
So let us 30 days. Today is
Third.
Today is. So we are fixing it on 2nd of January.
Correct. 2nd of January.
3rd of January.
3rd of January. 3rd of
3rd of
Third.
January. 3rd of January. Okay. In view of order passed in ISC 198 AP 2024 in the main case, the election, the respondent is permitted to file. Time for filing written statement is extended till 30.
Only if your lordship is not inconvenient to your lordship, my learned friend. On a bit of after 3rd, it
Yes,
can.
you give a conscience. 6th
6th, yes. Then
6th of January. In view of the order passed in to main case ISC 198 AP 2024 and earlier order passed in ISC number 197 AP 2024 dated, both one is dated today and other is dated 11/11/2024. Okay, not 11/11, 23/10/2000. 23/10/2024. The election and the respondents, that election petition stands adjourned till 6th of January 2024 to enable the respondent to file their written statement.
And without any prejudice will be
Okay.
also be allowed to.
That's
already
already there.
Yes.
That's already there. You
Yes.
can file. That is already there. Yes. Over. Okay.
Okay. Doubly obliged.
Lordship, I'm appearing on behalf of Senior Counsel Mr. B.D. Das, Lordship. We'll have to follow up in this matter, Lordship. You will kindly accommodate us for the day, Lord.
Okay. You just follow it up.
Lordship.
It is you are Mr.
HR does.
HR Das. Learned counsel submits that they may be granted some time to have complete instruction from their client in as much as this matter is pending since 2012. Prayer is allowed. List this matter on.
Any day next week, Lordship.
Give a date next week. 6th. Any information?
Lordship, it will take some time because branches, Lordship, it has been, I don't know which branch I have sent to AC1. As per the instruction of the, I mean to say the pedagogy officer. But they are saying that it is.
They have given a death certificate.
Lordship, correct. I also know this person because the client belongs to our chamber only. Very good gentleman.
So he expired.
It expired.
We'll close it.
But let the department because I'm afraid of the department.
Why you are afraid of the department? You should not be. You are none other than a special public
Correct,
prosecutor.
Lordship, that is correct. But
You know, you have your own knowledge. You yourself know what more is required for this court. Only the difficulty is that sometimes there may be some misrepresentation, something
Correct,
like that. Where Mr. Kotok is there, you are here, you know that this person is died. Okay,
Only
we'll
one
close
chance-
it. We will not
Lordship,
go to all
Lordship,
this.
Kindly one chance, sorry.
No one will
the-
say that
by the
Mr.
days next week,
Mr. Public Prosecutor submits
No, Lordship.
that
Let-
he has not received any instruction. However, he has his personal knowledge that this man has expired. Matter ends there. We know nothing more than that.
Lordship, next week. Kindly, Lordship, we are
Okay.
request for only 1 week.
Don't be, you are a special
I
public
understand,
prosecutor.
Lord.
Don't
I
don't
understand.
think yourself to be under the officers of the CBI.
That is, Lordship, that is a procedure, that is what.
What procedure and made for the justice? If you are aware, he is aware. We have faith on you. Matter is there. That's why these cases are pending since
By
2012.
Monday, Lordship, will.
My Monday.
Kindly.
6th of December. Yes.
Next.
Yes. It is the matter 15 and 16. I waited now. Item 16. None. MS P. Chakraborty Learned Counsel for the appellant submits that brief has been withdrawn from her chamber. Accordingly, she is not in a position to argue this matter. In view of the aforesaid, so this matter is pending since 2014 and record reveals that no counsel has subsequently been engaged by the appellant. In view of the aforesaid, let give a name. Was it let Sri Atal Tiwari be appointed as a amicus in this case. Full stop. Thereafter, the order I have was na registry to furnish the required papers to Mr. Kakolo Atal Tiwari and list this matter in the orders columns. When? 10th of December, reflecting name of Mr. Atal Tiwari.